Well, hello, everybody. Hey, Bill O'Leary coming to you live. Although it's Friday, this is part of a weekly thing I do on Thirsty Thursday. It's called our Thirsty Thursday series. I'm just running a day behind because I've gotten jammed up at work. But it's where I go live. I talk about something that I run across, people talk about in what I do. So what I do for a living, I'm a lawyer. I do estate planning, wills, trusts, estates, that sort of thing, elder law, probate, just focus on those areas. So, as I like to start off all of these Thursday talks, if you're thirsting for knowledge and for information, you've come to the right place. So, today I want to talk about guardianship. This came up earlier in the week in a certain situation I had. When does somebody need financial guardianship? And I'm thinking more of an adult that needs help, not a minor child. So, when someone can't manage their finances anymore, it can create a real problem. Pretty obvious. Don't need to tell you that. So just imagine the financial matters that you maybe encounter on a weekly basis, monthly basis, daily basis, paying bills, banking transactions, withdrawals, deposits, that sort of thing, dealing with financial institutions. So if your loved one gets to that point, how are they going to handle their affairs? Well, they really can't. So how are their affairs going to be handled if they can't? Where are they going to get help? One option, sometimes the only option that's left, is called a financial guardianship, where a court appoints a guardian. Some states, by the way, call it a conservatorship. We call it a guardianship here in Florida. So the process, it starts by, let's say, a family member um, uh, opening up a legal case and filing a couple of important things to get the process started. Two things, what are called petitions. One, a petition to determine incapacity of the person that needs the help, and a second, a petition to for appointment of a guardian, asking that the court appoint them as a guardian. And by the way, this process often takes several months, so just be patient. Now, courts will appoint these guardians, these financial guardians, in situations where maybe it's shown that someone can't handle their finances on their own. For example, think of these situations. Maybe somebody often forgets to pay their bills. They need help remembering to pay their bills and sort of deal with transactions. Or maybe somebody who's vulnerable to financial exploitation. They're gullible. So maybe think of someone who has been scammed by an online scammer, and it could happen again. Maybe someone with a disability that prevents them from understanding money, and they're going to need help from a trusted person. So here, maybe think of somebody, family member perhaps, with dementia, where maybe their decision-making skills, their executive functioning skills are impaired. Now, at the end of the process, that legal process, somebody is appointed as a legal guardian of the ward. Not the best term. I don't frankly like it, but it's sort of in the lexicon of the guardianship legal process. The ward is the person that needs the help. They're the person found to be incapacitated by the court. And the financial guardianship, it gives the legally appointed guardian the authority to oversee the ward's, let's say, the protected person's finances, and gain access to their money to be able to pay bills, conduct transactions, like I said, on their behalf. Now, in a lot of guardianship cases, not all, but seems like increasingly more and more, the judge requires the guardian to get prior court approval um, before taking certain financial actions on behalf of the ward, maybe larger transactions or selling assets. So a lot of times what will happen is the judge will require a special bank account be opened up called a restricted account. So the guardian can use the money in the account for the ward, but with restrictions and need to get court approval for certain transactions, just a way for the court to keep sort of a set of eyes on the guardian to make sure that the money is being used in the best interest of the ward. That's the ultimate objective. Now, there are some other options besides a guardianship to help someone manage their affairs. And again, without having to set up a guardianship. So, in fact, before a judge will even set up a guardianship, the judge is going to make a determination. Was there another way? Was there a better way that wasn't quite as restrictive as a guardianship where somebody's legal rights are taken away? This is what we call searching for a lesser restrictive alternative, because after all, 21st century, we're an enlightened society. We're reluctant, resistant for good reason to take away people's rights unless it's absolutely necessary. So another option besides a full-blown guardianship is called a guardianship advocacy. I call this guardianship light. It's not a full-blown guardianship. But it is a legal proceeding where someone is appointed rather than the guardian, they're appointed as the guardian advocate, and they have authority over certain decisions and functions. But importantly, legal rights are not taken away from the ward, and no finding of incapacity is made. So, depending on the situation, it may be appropriate to sort of do that guardianship advocacy. And then the least restrictive alternative is the good old-fashioned power of attorney, POA. And I'm sure you've heard of that. It's where someone signs a POA, giving authority to someone else to make financial decisions. Now, as you might expect, this option only works if the person still has the mental competency to be able to sign a legal document like a POA, understand what they're signing, have the ability to do that. If the impairment is too far gone, then the POA option is no longer available. And by the way, even with the POA, keep in mind that the person that signs the POA still retains all of his or her legal rights, which means retaining the right to make a bad decision. Maybe like making himself or herself vulnerable to being unduly influenced by somebody who wants to take advantage of them. So if the concern is somebody that is susceptible to undue influence, a lot of times I say, well, the POA might be an option, but it may not be enough. So if you'd like to know a little bit more about when does somebody actually need a financial guardianship, maybe some of these other options in lieu of that, and maybe how we can help, we'd love to talk to you. So we invite you, as we do with all these talks, go ahead, take that first step, reach out, schedule a free 15-minute phone call on our scheduling. And just go to our website, Legacy Planning Law Group, click on the book your free call button, and it takes you to a booking calendar. Pick a time that works for you. We'll jump on the call. Tell us what time you're mine. By the way, that call is complimentary. If you have enjoyed this video, like and share, and do subscribe, by the way, to our YouTube channel, Legacy Planning Law Group. We're getting more and more traction, more and more content put up all the time. So I hope you've enjoyed this talk about financial guardianship. I plan on giving another talk next Thursday about the same time. So if you're thirsting for knowledge, we will quench your thirst. So I'm going to sign off. Bill O'Leary, go make it a great day. Make it a better world, and have a great weekend, everybody.